librarian Ana Beatriz welcomed a pet in her house, a month-old woolly monkey named Estrellita. The monkey grew up with Ana and her family for 18 years. Estrellita even learned to communicate with them through gestures and sounds, as well as acquiring their family's customs. One day, their neighbor discovered that Ana and her family had possession of a wild animal without a license and immediately informed the local authorities. The authorities came and seized the monkey from Ana and transferred it to the local zoo. Estrellita was struggling to adapt to her new life at this zoo and died 3 weeks later. Necropsy later revealed that the reason for death was a cardiorespiratory arrest, and its causes were nutritional deficiencies, exposure to unfavorable environmental conditions, confinement, as well as mistreatment. Ana was furious after hearing this and took legal action against the authorities, stating that the animal's rights had been violated after being forcibly removed from a habitat it was comfortable in, eventually leading to its death. What followed is far more complicated than it seems, but before understanding what happened at the court, let's first understand the country in which this case took place. Ecuador, one of the most biodiverse places on Earth, with 26 habitat types and 20% of Earth's bird diversity. But as far as the natural world is concerned, biodiversity is not the only thing Ecuador is famous for. You see, Ecuador is a leading example of a country where policy upholds the integrity of the natural world. In 2008, Ecuador became the first country in the world to grant Mother Nature the right to exist. According to the Rights of Nature Act, Articles 71 to 74, all of nature in Ecuador has the right to exist, flourish, and evolve. This is absolutely brilliant because Ecuador has opted for a unique, almost an indigenous worldview towards the natural world, treating it as a subject with rights rather than an object or a resource for humans to exploit. Now, coming back to the woolly monkey incident, when Ana Beatriz went to court with the case of a dead pet monkey, there was one underlying problem. The problem that who had actually been violating the animal's rights. Yes, according to Ana, the government authorities forcibly snatched Estrellita away, causing extreme stress to the animal and violating its rights. But at the same time, Ana had also been violating Estrellita's rights for 18 years. Estrellita was illegally trafficked from the wild when her mother was killed and she was sold only when she was a month-old baby. Much to Ana's surprise, the court ruled that both the authorities as well as Ana had violated the animal's rights. And if you think about it from a cognitive perspective, removing social creatures like primates from familiar environments and confining them in a small cage was never going to work out well. The authorities, although they did their job, should have considered the mental circumstances of the animal. And if you think about it from an ecological perspective, no human can provide the same amount of care to an animal better than its own mother can. And by buying Estrellita, Ana had participated in the illegal wildlife trade, which was the reason for the death of Estrellita's mother. The Ecuador's Constitutional Court did not have a strong framework for this particular case because the 2008 Rights for Nature Act we discussed earlier did not take individual animals into consideration, but rather their entire habitat by preventing things like mining in biodiversity hotspots, providing rights for natural preservation. But it talks absolutely nothing about the rights for individual animals like Estrellita. What kind of rights did she have? So the Ecuador's Constitutional Court, the highest law order in Ecuador, proposed a new legislation to be drafted after Estrellita's case. And now, wild animals in Ecuador possess the legal right to exist, develop their innate instincts, and be free from disproportionate cruelty, fear, and distress. According to Kristen Stilt, a Harvard law professor, what makes this decision so important is that now the rights of nature can be used to benefit small groups or individual animals, making it a far more powerful tool than perhaps we have seen before. However, despite all of these things, there are some aspects that still should be addressed. Individual wild animals in Ecuador possess the legal right to exist and be free from disproportionate cruelty, fear, and distress, But this statement raises important questions like, why is this rights not extended to domestic animals? Because aren't they individual living beings? Yet still they have to go through cruelty, fear and distress. And it should apply to domestic animals because as per the Rights of Nature Act, the definition of nature is defined as a place where life reproduced and occurs. Doesn't life occur in farms? Doesn't life reproduce in farms? But the Ecuador's court just refused to delve into such questions. The second criticism to the Rights of Nature Act is that it is not enforced when oil and mining industries come into the picture. These two industries are one of the most destructive ways to harm the natural world. Yet these exploitative industries are the driving force of Ecuador's economy, and it seems like it will remain so in the near future. As you can tell, there's still a lot of work to be done, but it is absolutely brilliant that Ecuador has begun to rethink the human-nature relationships. Taking such measures in the kind of world that we live in today is not an easy task, and Ecuador has faced a variety of challenges to uphold this law. Of course, there will be fishing, hunting, and forestry, but it is only allowed if done as per the law, not at the expense of risking endangered species and in a way that limits suffering. And the good news is that wild animals of Ecuador have now moved from being something for humans to someone for nature.